Good day. I am Dr. Martha M. Bradley. Welcome to your lecture on Customary International Law as a primary source of public international law. In order to avoid fatigue, this lecture is divided into 3 installments: Part A, Part B, and Part C. Please engage with these videos in the sequence it is numbered. In the first substantive part of this presentation, Part A of your lecture, I will provide a brief introduction to customary international law in general, and then, in the second substantive part, explain the uses requirements in detail, and in the third part of this lecture, I will explain the opinio juris element of customary international law in detail. In Part B, the next installment of your lecture on customary international law as a primary source of public international law, I will explain the notion of the persistent objector, and I will examine the relationship between customary international law and the other sources of public international law. In Part C, I will explain the contribution of the Jordan case of the ICC to the understanding of this source, and finally, I will highlight the continued importance of customary international law by offering some contemporary examples of customary international law rules. The learning objectives of this first installment of your lecture are to, first, be able to define customary international law as a primary source of law with reference to authority. Second, you have to be able to identify, understand, define, and differentiate the 2 requirements of customary international law. Third, you have to be able to understand and apply the threshold requirements inherent in customary international law. In other words, when is state practice sufficient to transform a norm into the realm of a rule of customary international law? The fourth learning outcome of this lecture, you have to be able to list the sources where uses and opinio juris are found, and further, be able to ascertain evidence of uses and opinio juris in practice from these relevant sources. Please consult your class notes during this lecture. This section of our lecture intends to provide you with a broad understanding of customary international law. The process in the formation of customary international law is the same in all fields of international law. Consequently, the approach in determining the rules of customary public international law and customary international humanitarian law, or for example, customary international environmental law, is the same. Article 38(1)(b) of the Statute of the International Court of Justice, the ICJ, cites customary international law as a primary source of public international law. This provision is provided for on page 2 of your lecture notes. This source is defined in Article 38(1)(b) of the ICJ statute as international custom as evidence of a general practice accepted as law. So from this definition, it is very important to underscore that it refers to a general practice and then acceptance as law. The wording in this provision is significant, as it encompasses the 2 requirements needed for a rule to reach customary international law status. First, as I mentioned before, evidence of general practice refers to what is termed the uses requirement. And second, accepted as law, which refers to what is known as the opinio juris requirement. You will see an equation on page 2 of your notes to help you envision these 2 requirements. We will now turn to the uses requirements, which is provided for on pages 3 to 5 of your lecture notes. The uses requirement essentially refers to the actual practice of states which is consistent with a rule of international law. The North Sea Continental Shelf case considered state practice related to a relevant international law rule, including the practice of especially affected states to be extensive and virtually uniform. In the North Sea Continental Shelf cases, the ICJ summarized the uses requirement as the practice of a rule by a state that should moreover have occurred in such a way as to show general recognition that a rule of law or obligation is involved. During its 64th session, the International Law Commission decided to place on its agenda the topic Formation and Evidence of Customary International Law. Subsequently, the Law Commission released 5 reports on the formation and evidence of customary international law under the guidance of Sir Michael Wood, the Special Rapporteur tasked with fulfilling this mandate. These reports offer insight into the formation of customary international law generally, and specifically deal with the 2 requirements necessary to establish custom, as well as giving evidence of the existence of these requirements. The second ILC report on the identification of customary international law comments that uses, or general practice, is the conduct of states, very important, the conduct of states, not non-state actors, emphasis, conduct of states, which is of primary importance for the formation and identification of customary international law, and the material element of customary international law, thus, is commonly referred to as state practice, that is, conduct, which is attributable to states. Draft Conclusion 6 echoes this determination and regards state practice as conduct attributable to the state, irrespective of whether such practice is exercised by its executive, legislative, judicial, or other functions. Draft Conclusion 9 determines that in order to be sufficient to establish a rule of customary international law, state practice must be general, but need not be universal, and it must be generally consistent. The draft conclusions adopted on the first reading, and which serve as the addendum to the 5th report, take into account the commentaries made by states, specifically Conclusion 8 of the draft conclusions adopted on first reading, with the Special Rapporteur's suggested changes, which elaborates on the general nature of state practice. It amended the threshold test, which previously read that practice must be consistent, to read that practice must be virtually uniform. Virtually uniform. You can see that this is a very high threshold. For virtual uniformity, it seems that virtually almost all states must have that same practice. The agreed upon nature of practice is summed up in Conclusion 8.1 of the 5th report as follows. The relevant practice must be general, meaning that it must be sufficiently widespread and representative as well as virtually uniform. And this is very important, so I am going to repeat Conclusion 8.1 of the 5th report, which introduces the standard. How much state practice do we need for a norm to equate a customary rule of international law? So I'm going to repeat this. The relevant practice must be general, meaning that it must be sufficiently widespread and representative as well as virtually uniform. The Special Rapporteur responded to the call of states to replace the term consistent with virtually uniform and expressed the hope that the threshold virtually uniform more accurately captures the generality requirement than the term consistent. The phrase virtually uniform is concordant with the wording the ICJ employed in the North Sea Continental Shelf judgment to refer to the requirement of general practice. The North Sea Continental Shelf judgment, however, uses the phrases extensive and virtually uniform, a settled practice, and very widespread and representative interchangeably to refer to the threshold necessitated by the requirement of sufficient general practice. The Special Rapporteur pointed out that case law refers to the general practice as meaning practice that is, in general, consistent, established and substantial, uniform and widespread, or constant and uniform. The Special Rapporteur cautioned that none of these expressions, and this is important, defines the exact quantum and quality of practice needed to identify a rule of customary international law. He offered the following solution to this problem. So essentially the problem is that the threshold of virtual uniformity does not tell us, for example, that the practice of 190 out of 194 states are sufficient to equate to custom, or the practice of 170 of 194 states are sufficient to equate custom. No. So Sir Michael Wood offered the following solution to this problem. A certain practice must be general enough to give rise to or express a rule of customary international law, and also in providing for some measure of flexibility, reflecting the inherent nature of this source of international law. So I want to repeat this. So the solution that he offered in terms of what does this mean? How much practice constitutes virtual uniformity? He says that practice of states, state practice, has to be general enough to give rise to or express a rule of customary international law, and also in providing for some measures of flexibility, reflecting the inherent nature of this source of international law. Draft conclusion 9 of the first report determines that if the practice is sufficiently general and consistent, no particular duration is required for such a practice to be regarded as usus, a position reinforced in the fifth report. We now turn to discussion of the second requirement, opinio juris. Opinio juris. You can find notes regarding this section of our lecture on pages 6 to 7 of your lecture notes. The second requirement, opinio juris, is referred to as the psychological element in customary international law. This requirement refers to the subjective attitude of a state. The fact that a state acts in compliance with a rule as it is the opinion that it is obligatory to do so, as such a rule is a rule of law. The International Court of Justice distinguishes customary international law from mere ceremonial acts or protocol, where the intent is to adhere to a rule not because of a belief that the state is under any legal obligation to do so, but because such an action is motivated by considerations of courtesy or tradition. In the North Sea Continental Shelf case, the ICJ articulated the relationship between the uses and opinio juris requirements of international customary law to be as follows. Not only must the acts concerned amount to a settled practice, but they must also be such or be carried out in such a way as to be evidence, and this is where opinio juris comes in, listen to this language, as to be evidence of a belief that this practice is rendered obligatory by the existence of a rule of law requiring it. The need for such a belief is the existence of a subjective element, is implicit in the very notion of the opinio juris sive necessitatis. The states concerned must therefore feel that they are conforming to what amounts to a legal obligation. In the Nicaragua case, the ICJ articulated the opinio juris requirement to be evidence of a belief that state practice is binding, owing to the existence of an obligatory rule of law. The ICL confirms that it is the very need that requires such a belief, which serves not only as evidence of the subjective requirements, but also that such a need is inherent in the very notion of opinio juris sive necessitatis. In the more recent case of Germany versus Italy, the court formulated the test to determine whether the opinio juris requirement has been satisfied as being an obligation imposed upon states by international law to abide by the rule in question. The second report on the identification of customary international law eloquently phrases the opinio juris requirement as feeling legally compelled to perform the relevant act by reasons of a rule of customary law obliging them to do so. So this definition is very important. You can see that there is a psychological underpinning to this opinio juris requirement because the state feels legally compelled to act in a certain way because it believes that there is an existing customary international law rule obliging the state to do so. Conclusion 9 in the draft conclusions adopted on first reading with the Special Rapporteur's suggested changes and next to the fifth report formulates the requirement of the acceptance as law opinio juris as follows. First, the requirement is a constituent element of customary international law that the general practice be accepted as law opinio juris means that practice in question must be undertaken with a sense of a legal right or obligation. So this is very important. The first requirement means that opinio juris, that the practice in question, the way states act, must be undertaken with a sense of legal rights or obligation. A general practice that is accepted as law opinio juris is to be distinguished from mere usage or habit. So you have to be able to distinguish general practice that constitutes also through the light or manifests through the lights of opinio juris from mere usage, courtesy, or habit. The fifth report lists forms of evidence for acceptance as law, which includes but are not limited to official state publications, public statements made on behalf of the state, diplomatic correspondence, government legal opinions, decisions of national courts, treaty provisions, and conduct in connection with resolutions adopted by international organizations or an intergovernmental conference. So, what is the takeaway from this lecture? In short, customary international law is the primary source of public international law which binds all states. The two basic elements that must be present to constitute a rule of customary international law is that of usus and opinio juris. The level of state practice needed to constitute a rule of customary international law is that of virtual uniformity which is indeed a very high threshold. You need to know the sources of usus and opinio juris in order to establish if this threshold is satisfied. This brings us to the end of this first installment of your lecture on customary international law. Please continue to watch the second installment of your lecture and after that, the third installment. Thank you for your attention.